Thank you, everyone. Welcome to the January 14th meeting of the Scarborough Zoning Board of Appeals. We will start off, as always, with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Doreen, will you call the roll, please?
Peter Freilinger.
Here.
David Bork.
Here.
Michelle Stevenson. Here. Richard Silkman.
Here, this on Zoom call.
Absent is Joe Doherty and Kyle Noonan.
Terrific. Thanks very much, Richard. Richard, we're going to keep one eye on the screen if you raise your hand to say anything. So we are trying to pay attention to you, but if you need to get our attention, do what you need to do.
You bet.
Terrific. Okay. With that, this is again, this is the January 14th meeting of the Town Zoning Board of Appeals. This is a public meeting. However, we limit public comment to specific times during the agenda, and I'll go through that as we go through the agenda. We act according to a written agenda which has been posted to the town website. No other matters will be taken up that have not been added unless a board member wishes to bring up another matter at the end of the meeting. With that, we will first go through the approval of the minutes. We will then approve the findings of facts from our prior December 14th meeting, or excuse me, December 16th meeting, I think, December 10th. And then we'll go on to the one active item tonight, which is an administrative appeal. We typically don't deal with administrative appeals. These are unusual items. So when we get to that item, I'll talk through the process that we'll be observing. And also, we have on the agenda tonight the election of officers. We anticipate potentially getting new members next month. We are shy a couple members right now, so we're going to defer that item until February. With that, do I have a motion to approve the minutes for December 10th?
So moved.
Thank you. A second?
I'll second that.
Terrific. Doreen, you want to call?
Peter Freilinger.
Yes.
David Bork.
Yes.
Michelle Stevenson.
Yes.
And Richard Silkman.
Yes.
Terrific. That motion passes. The next one is 401, the written decision for a shoreland setback greatest practical extent determination at 105 Spurlink Road. Did everyone have a chance to read the decision? And again, shoreland setback determinations are a little bit different than our normal findings of facts, but we appreciate staff for putting together a form that was effective for that. So thank you very much. Do I have a motion to approve the final written decision?
So moved.
Thank you. Second?
I'll second that.
Great. Why don't we just do a show of hands on these? All in favor? Richard raises his hand too. That is unanimous. Thank you very much. That is approved. 402, the written decision for Appeal 2789, a miscellaneous appeal at 92 Broad Turn Road. Again, we had a couple of motions on this one. We both effectively updated our findings of facts from the prior approval of the Broad Turn Road miscellaneous appeal, and then applied those findings of fact to the entirety of the property. So there was, again, came through on the decision. Were there any other comments on that one? That was a little bit more complicated. Great. See nothing from Richard either. Do I have a motion to approve?
So moved.
Thank you. Second?
Second.
Thank you, Shelley. And a show of hands to approve 2789. That's unanimous. Thank you. And then a more typical one, the written decision for Appeal 2790, variance appeal on 128 Winnick's Neck Road. This was declined. Do I have a motion to approve the finding?
So moved.
Thank you.
Second.
Thank you. All those in favor? And that is also denied. Okay, we will now move on to the administrative appeal by Pretty Flaherty on behalf of New Seaward on the Ocean Front, Inc., 5 Bliss Street. Again, this is an administrative appeal, so we go through a little bit different procedure. What I'd like to do today is give the appellant 15 minutes to go through their case. Is 15 minutes enough, do you think?
I believe it should be, to the extent that we run over 15 minutes, it would only be by 1 or 2.
Got it. That's great. We'll then give the board a chance to ask questions of the appellant and their representation. We'll also then take a quick break. I was informed outside that there's a desire for public comment. So we'll have a quick break for a public comment or two. And then we'll give the town and the code enforcement office a chance to reply. We will then, again, 15 minutes is sort of our goal.
Should be more than enough, and I do know that the property owner has some representatives here as well. Would that be the real party in interest for the permit? We're happy to have them go first, but ultimately, Mr. Chair, it's your preference.
Well, that was the intention. Yeah, the representative from Pretty Flaherty. Is the owner going to also be speaking, or is it just the representative?
It should just be me tonight, potentially my colleague, Kristen Collins, who is attending via Zoom.
Okay, got it.
I meant the owner of the property subject to permit. So the owners of 5 Bliss Street.
Gotcha. Okay, those would be part of your discussion then.
So they're separate parties.
Yep.
But they have an interest in defending the issuance of the permit.
No, I guess my point is that I'll ask the appellant to go first, then you, then them.
Sure.
If that makes sense for the
That's
time.
my preference.
Okay. But after each speaker, I'd like to give the board a chance to ask questions of that speaker. So to the extent the property owner is here, you'd go after we ask questions of the town, if that makes sense. Terrific. Okay. So with that, representative from the appellant, again, speak into the mic at the podium, and again, approximately 15 minutes. But again, we're not going to hold you to that.
All right, thank you very much. So, good evening. My name is Gray Lewis. I'm here tonight representing the appellant in this matter, New Seaward. With me are Lisa, Evan, and Ben Kennedy. As I said earlier, also attending tonight is my colleague, Kristen Collins, via Zoom.
Actually, are they on Zoom? We don't have them listed up there.
If he is not, then it is just me here tonight.
Okay, got it. Fair enough.
This appeal has been filed because the town erred in issuing permit number 202-50571 related to proposed construction at 5 Bliss Street. This permit was issued in error for 2 reasons. First, it impermissibly expands a non-conforming and a non-conforming structure. And second, it constitutes a prohibited reconstruction. But before I get into the meat and potatoes of what underlies the appeal, I want to just briefly recap what is proposed to be constructed here so that we're all on the same page. So at the heart of New Seaward's appeal are 2 expansions. I'm going to refer to them tonight as the front expansion and the side expansion. Unsurprisingly, the front expansion occurs at the front of the building, and the side expansion occurs on the side. I hope we can all keep that straight. So the front expansion will entail the addition of a roof deck on top of an already existing, screened-in porch, three-season room type of structure. That three-season screened-in porch is located within the required setback imposed by the bulk and space standards of the town zoning ordinance, and therefore, by extension, the proposed roof deck would also sit within that setback. Currently above that, three-season fenced-in or screened-in porch rather is air. There's nothing there. The proposed roof deck would be taking up that space. Now I'm going to turn to the second expansion, the side expansion, and again, that takes place on the side of the building. That expansion would entail the demolition of an existing greenhouse that is partially sunk into the earth to the point where even the foundation would be removed. That area would then have a new bathroom rebuilt along the existing footprint of that greenhouse. And on top of that, another deck would be built. Similar to the front expansion, this new deck would be taking up the space that is now not occupied. It's just plain old air. In addition, this greenhouse, and by extension, the proposed bathroom and roof deck above it, are sitting within that setback requirement imposed by the bulk and space standards. Specifically, it is 6 feet away from the property line. No variance has been granted for this proposed structure, this proposed expansion on the side. This board is a board of appeals. As such, I'm sure you are all well versed in non-conforming structures, uses, provisions related to those, and so I won't really dive into that too much, but I just want to highlight that, as you know, the purpose of non-conforming provisions is to remove non-conformities over time. Obviously, there are situations in which a non-conforming use or a non-conforming structure is grandfathered in. And there are situations where a building can be demolished and replaced in a non-conforming, or a non-conforming building could be demolished and replaced if there is a like-for-like switch. You all know this. But when there is a change in use or a change in the nature of that structure, that is when non-conforming structures or uses are intended to be phased out so as to bring the town into conformity with its zoning ordinance over time. Now we get really to the heart of this appeal. As I said, these permits were issued in error for 2 reasons. First, they impermissibly expand the structure, and second, they allow for prohibited reconstruction. I'm going to start with expansion. To do this, we first need to look at the zoning ordinance. So I'll direct you to the ordinance, chapter 405, section 3C. And I'll pause for a second until everyone's with me because I'm about to read it off right here. But it provides that no building or structure which is non-conforming with respect to the space and bulk requirements of this ordinance may be expanded, enlarged, or increased in height unless such expanded or enlarged portion complies with the space and bulk requirements. As we've said, both the side expansion and the front expansion are within the required setback, so they do not conform to the space and bulk requirements. Accordingly, they are impermissible if they constitute an expansion or an enlargement. Unfortunately, the ordinance doesn't define either of those terms. If it did, we probably wouldn't be here tonight. But in the absence of an ordinance definition, there are certain ways that you as the board can interpret the term enlarge or expand. One of those ways is to look for the common meaning of the term as folks in their everyday lives use it. The second way is to look for the intent of the town when it crafted this ordinance and what it intended those words to mean. The CEO in the town, posits that the work doesn't constitute an enlargement because it does not enclose any existing open space, it doesn't increase the height of the structure, and it doesn't expand its footprint. We would push back on those assertions. As stated, there are going to be, roof decks imposed. Those roof decks by, code requires that they be semi-enclosed with railings. That could constitute an enclosure of space. In addition, the usable floor area of the home will increase by the addition of these roof decks. That could be considered an increase as well. But really the fundamental point here is that in limiting the definition of enlargement or expansion to these three specific criteria, the town impermissibly narrows what this definition should be, and it does not comport with the commonly understood meaning of that term. For example, often folks, when they think about enlarging a structure, think about enlarging the usable floor space of that structure. If, I had a house and it had 500 square feet of usable space, and, then I put on an addition and it increased to 1,000 square feet of usable space, I would think that that home was enlarged. Similarly here, the usable floor space of this home is going to increase. There are 2 roof decks that are going to be added. Folks can go out there, folks can recreate there, folks can use that space. In addition, we would argue that, volume is a commonly understood criteria when determining if something expands. This is a poor analogy, but let's say I have a little, those blocks that children play with, little square cubes. If I put one on my desk right here, and I put one right on top of it, and imagine that they were joined, the volume of that would double, but the square footage wouldn't. But because the volume of it increases, we would just commonly understand that that structure has enlarged itself, has expanded. Accordingly, when we use a common understanding of the term enlarge or expand, we look to this kind of smell test, for lack of a better term. As I know that word, to what I know that word means in my common understanding, does it seem like the structure has been enlarged? And we would argue that the addition of these roof decks undoubtedly expands the usable space and thus the structure itself. But I also mentioned that there was another way that we can, look to what a term should mean when there is no ordinance, specified definition. And one is to look for the intent of what the town meant when it used that term in the ordinance. And now I'm going to direct you back to the language of the ordinance itself. Section 3 of the the non-conformant section of the statute, or of the ordinance rather, is section 3. Part CA talks about dormers and how the addition of dormers can be an exception to this expansion requirement. Essentially, if you meet these specific dormer requirements, it is not considered an enlargement. And I'll read the language here because it's pretty specific. Section CA says, the installation of one or more dormers on a dwelling shall not be considered an expansion, enlargement, or increase in height, provided that 1, dormer or dormers are set in a minimum of 12 inches from each end of the roof and from the exterior face of the story immediately below the roof. 2, the aggregate length of all dormers measured along their faces does not exceed the total length of the ridge of the roof less 24 inches. And 3, the height of the ridge is not increased. Now, I know we're not here to talk about dormers. I acknowledge that, but this language is really informative. The reason being is that shoreland zoning requirements used to use volume as a criteria when determining whether or not a structure had been enlarged. To allow folks to put dormers on their house and not increase or enlarge the structure and violate these non-conforming provisions within a shoreland zone, many towns put in this exact language to create an exception. Now, the requirement that volume be included as a criteria when determining if something has been enlarged has been removed. And as a result, many towns don't require that anymore. But those towns have also removed this exact language, this exception, because it's no longer necessary. The fact that this exception still exists within Scarborough's ordinance suggests that not only did the town intend for volume to be a measure of enlargement when it created this statute, it still does because the language hasn't itself been removed. I also think it's worth noting that this dormer requirement is hyper-specific. For example, you have to make sure that the total length of the ridge of the roof is not exceeding 24 inches. And it follows then that if someone put in a dormer that didn't meet these requirements, it would be considered an enlargement or an impermissible expansion. And I think it's worth asking, what is a roof deck? But an unfinished dormer, I look at them, and if you imagine a dormer that has had its roof cut off, it is essentially a deck out to the world. It strains reason to think that a dormer that, is a impermissible expansion because it does not meet this specific requirement would not be allowed, but an unfinished dormer would be under the town's current interpretation. Accordingly, we can see that using either a commonly understood definition of the term enlargement or expansion, or looking to what the town intended those words to mean, either would include these expansions. But not only does the structure itself constitute an impermissible expansion, we would argue that the proposed use would as well. As I'm sure you well know, being on a board of appeals, there can be non-conforming uses as well as non-conforming structures. Right now, the area above the front expansion is not used. It's empty space. Similarly, the area above the side expansion is not used. It is empty space. But in their stead, what is proposed is our roof decks. And this is included in the documents provided by the appellants. It's clear that the property in question, 5 Bliss Street, is being used as a vacation rental. It's currently advertised that it can sleep 19 individuals. It strains reason to think that a grandfathered use of essentially nothing above these proposed expansions can be increased to the point where 19 people could be 6 feet away from the property line. Obviously, uses that are consistent with previously allowed uses that are no longer that are allowed, that are now non-conforming, can be grandfathered in. But we would argue that this is a complete change in use, a change in intensity, and that is not within the the spirit or really the language of what this non-conformance ordinance is supposed to allow. Accordingly, whether we look at the use or the structure itself, what has been proposed is an impermissible expansion. Because it's an expansion, and because these expansions would sit within the required setback, they are not grandfathered in through the language in the ordinance, and the town erred in issuing the permit. But notwithstanding the expansion issue, the side expansion is also, prohibited for an entirely separate, independent, but equally valid reason. As I stated earlier, it is a prohibited reconstruction. So again, I'm going to have us turn back to the language of the zoning ordinance. And Chapter 405, Section 3C provides that quoting the wrong part. Chapter 405, Section 3C notes that if a non-conforming building or structure is demolished or removed by or for its owner, it shall not be rebuilt or replaced except in conformity with the space and bulk requirements of this ordinance, unless the Board of Appeals grants relief from such requirements by variance. Now, I think there's a couple really important things to note. First, no variance has been granted with respect to the side addition. Second, the side expansion would be within the setback. Third, this demolition is for the benefit of the owner. This is not an act of God. This is not a result from, an unusually high tide, an earthquake, etc. This is a pre-planned renovation. And third, this undoubtedly is a demolition and at the minimum a removal. What has been proposed here is not, some minor change. It is demolishing the greenhouse, even to the point of removing the foundation. It is going to be removed to the soil, and from there, a new structure will be rebuilt. If that isn't a demolition and removal, I honestly don't know what would constitute that. Accordingly, the expansion issue notwithstanding, this side addition, the side expansion as well, is an impermissible reconstruction. Accordingly, for the foregoing reasons, we believe that the CEO issued this permit in error and would request that this board grant the appeal and reverse the CEO's decision. I understand that there's questions coming from the board, and so I'm happy to pause there and see what you all want to know.
Yes, that'd be great if we could. Fellow board members and also Richard. Richard, let me start with you because you're on Zoom. Do you have any questions to pose to the,
Yes, I do have a couple of questions. You mentioned the use of commonly accepted terms, that when a term isn't defined in the ordinance, that you use what's commonly referred to as the definition of that term. I looked through the ordinance and I did not see the term demolition defined.
Mhm.
So my understanding then is you would use a common definition of demolition. And I did a little bit of research on that. And the general sense is that a demolition exists when up to 40 to 50% of the structure is removed. But here we're only removing a very small percent of the structure, 5% perhaps. And it seems to me that using the common definition of demolition, this would not be a demolition any more than if somebody were to, take away their garage door and replace it. Or deal with a foundation issue in back because of a drainage problem. So I don't see how your second argument conforms with the zoning ordinance that you quoted, because that requires a demolition. And this does not seem to be a demolition. Do you have any comments on that, or how do you view that?
Yes, of course. So you are correct. When something is not defined as demolition is not defined here, we should look to the commonly understood meaning. So I think you hit the nail on the head there. But what I would say is that, what we're seeing here can be considered a demolition under the commonly understood meaning. First, I acknowledge that the entirety of the building is not being demolished, only a small portion is. But the entirety of the portion that is pertinent, that is non-conforming, is being demolished and removed. In addition, I think that's really the crux of our argument. I agree that if you don't consider this to be a demolition, that second argument doesn't hold a lot of water. But, in looking at, other types of constructions that can occur, if we have a house and it has an attached garage and the garage is knocked over, but the house itself is left intact. I think many folks would say that the garage was demolished. The house was left be, but the garage itself had been removed from the property. And that's exactly what we're saying is occurring here. The current addition, and if you look in your appeal packet, there's a photo of the side expansion. It doesn't look contiguous to the house. It's a odd little add-on, similar to an attached garage. It's not part of the, overall, cohesive structure. And we'd argue that, that portion in its entirety is being demolished as someone walking down the street would understand that term to be. But, obviously, Mr. Silkman, if, you are on the board and it's your interpretation of that term that matters. But in making a decision about what your interpretation is, I would encourage you to, look to what, folks down the road, anyone else in this room might consider to be a demolition and really what passes the smell test. If part of a structure was there and now it's completely gone, it has been removed. It has been demolished.
The other question I had is with respect to the enlargement of space.
Mhm.
Currently, my understanding is that if we look at a particular building and we think about its living space, the zoning ordinance defines living space as fairly broad, but what it does not are things like attics and garages. So that's not part of the living space in the definition. So is it your position that if somebody in a non-conforming building wanted to somehow convert an attic space into living space, they would not be allowed to do so without a variance?
So
Or would not be allowed to do the same thing with a garage?
So you cut out just for a second, so please let me know if I don't actually answer what you're asking. But it sounds like what you're asking is if something doesn't increase the living space, can it be considered an expansion? Is that the crux of what you're trying to get at?
If something does increase the living space, would
Understood.
it be considered an expansion? And therefore require, under your concept of enlargement, a variance?
So yes, essentially, yes, an increase in living space that does not conform with the space and bulk standards as this increase would need to be, allowed via a variance. And that's, simply the only way if it doesn't meet these requirements, which it sounds like what you're describing does not. We'd also argue that, an increase in the usable square footage on these roof decks is an increase in living space. And I don't think that that's too contentious of a position to take, right? When you have a roof deck, you can barbecue out there, you can sunbathe out there, you can do whatever you want out there, you can live out there. It is living space.
But in the definition of a living space, it defines a space where it is used for a living.
Mhm.
I don't have it in front of me now, but you could check convenience. But also a space that is used for storing chattel. Now, this takes us back to the Middle Ages, but chattel includes, and again, I looked this up because I was concerned about plants, but it includes potted plants. So the greenhouse, under the current definition in the ordinance, is living space. And so tell me how it is that we are expanding the living space by just retrofitting and changing the use of the greenhouse to bathrooms and a deck compared to housing chattel.
I understand. Thank you for clarifying. We would argue that it's increasing the living space in two separate, well, we'd argue that it's an expansion in two ways. First, right now, the greenhouse is one floor. The proposed plans have one floor as a bathroom and an identically sized floor above it as a roof deck. The square or the usable floor space has increased twofold in that regard. Yes, the space formerly occupied by the greenhouse is going to be converted into a bathroom, but there is an additional equally sized space above it that will take the form of the roof deck. We'd also argue that there's been an expansion in the use of that area. Right now, the area above the greenhouse is empty. It's not being used for anything. It will be used for, well, who knows what, right? When a building can house 19 folks, I think it's going to be used pretty intensely. In addition, plants, and I can't admit that I have a green thumb or anything, but it is my understanding that, plants are pretty passive, right? You water them, you give them sun, they sit there. Bathrooms, meanwhile, have folks going in and out all day, especially when there's 19 of them living in a house, or visiting a house, rather. The non-conforming uses certainly can be grandfathered in. I'm not here to argue that. But when a use changes, when it becomes more intense than has previously been allowed, that is an expansion of that use. And that's what we're arguing is occurring here as well. Previously, the use was non-existent or passive at best. Now, in both the bathroom and the roof deck above the side expansion, it will be an intensive use 6 feet away from the property line.
I have a question. If Richard's okay.
By all means, good now. Yep, thank you.
You just said that we don't know what they're gonna use that for, but then you're also saying it's intense. So, I mean, who's to say that this bathroom is, you don't know how much I use my bathroom. No one's gonna see that. I have an issue with
Yeah,
that
that's fair.
argument right there. But what my other question was gonna be was, I looked at these plans earlier, and I was gonna just pull them up, but I didn't know if anybody had that answer to this off the top of their head. Is this deck going to be covered? Like enclosed in any way? So my follow-up question to that is, if they were to sell, if they're to sell this house, will that square footage of the decks be included in the sale of the house? Because that is a big point for me in the term expansion. Can they count that towards resale square footage? The bathroom, probably yes.
Yeah.
And actually, they're probably gonna lose square footage overall.
So it sounds like you asked three things and I
Yeah,
wanna.
I'm sorry.
No, that is completely all right. So first, I want to address your concern about how do I actually know what this space will be used for. You're right, I don't. But what we do know is that the house is listed as a vacation rental and it has been listed as being able to sleep 19 individuals. You know, the members of the board are residents of Scarborough. We all know that, you know, a lot of folks come here during the summer. I don't know specifically what these vacationers are going to be doing, but I think it's a fair assumption that they're going to be doing what other vacationers do. And you know, you can decide for yourself what that actually is. With regard to is the deck covered? No, it is not. It is in, I believe, and you know, the homeowners representatives can correct me on this as well as the CEO, but I believe that it is going to be, you know, fenced in with a railing so folks don't fall off. But I don't believe that it's going to have any sort of, you know, overhang or covering in that regard. With regard to whether or not the square footage could be included as, you know, as part of any sale, I don't know. You know, I haven't spoken with a realtor on this. I would think though, at the minimum, it would be a great thing to list as in any sort of description of the property. You know, even if it's not included in the square footage of the home, you'd say, you know, and 200 square feet of, you know, prime deck space. That sort of thing. And it may be included in the square footage of the home as well. I just don't know.
Thank
And
you.
actually, for the definition we have within our definition section, which is part of the zoning code, floor area would not include a porch because floor area only includes space enclosed
Okay.
by an exterior wall. So, yeah.
I didn't think so either, but that's not my specialty.
Sure.
So I just wanted to bring that up when we're talking about the definition of, you know, expansion and taking this area that's air and, you know, trying to give it more meaning. Sometimes when I'm looking at stuff personally, like if I was looking at real estate, I'm not getting money per square foot back on that. And that's why I asked that question to kind of bring that up.
I
Thank
would-
you for answering my
Yeah,
question.
pleasure. I would also like to highlight that even if the, you know, definition of floor space in the town's ordinance doesn't include decks, that doesn't mean that in any sort of real estate listing, it wouldn't be included.
And it doesn't mean
Yeah,
that
no,
it doesn't have
I
any,
just wanted to be clear on that one. It's because we were going back and forth with definitions and others. So that was just the,
yeah, no,
definition,
I
so,
appreciate
yeah.
that. And it doesn't mean that it doesn't have other added value. I just monetary value in terms of resale is what I was getting at.
anything else, Sean?
I don't think so.
Ben?
Great,
Go ahead.
okay. Yeah, a few things here. I'm looking at the building permit here and it shows the, you know, existing and proposed for three items. You know, one is stories, the second is bedrooms. Those numbers are 2 and 5 respectively, no change. And bathrooms, and those are the same also, 3.5 and 3.5. So why wasn't that listed on the permit? And to me, that seems like they're not permitted to add a bathroom. Is that the case?
What I would say is, you know, that might be outside of the scope of what we're here to discuss tonight. You know, to the extent that the town wants to look into that further, whether or not a bathroom is being added impermissibly, that is the town's prerogative. You know, what my clients are concerned with tonight is these impermissible expansions. You know, to the extent that that is an issue, I'm sure my clients would be, you know, ecstatic that it would, you know, inhibit this growth, but I don't think that's something that we can comment on.
Okay, that's kind of an odd way of looking at things. But and I'm also on the Board of Assessment Review.
Mhm.
And I can tell you that the town assessor will not count decks as livable space.
Okay.
It has to be fully enclosed
Mhm.
and heated. Okay, otherwise it's not, you know. And then to make the argument as you did, that the volume of that deck, you're trying to define volume on a flat surface when there are no sidewalls or roof to it. I find that very difficult to comprehend. Can you please try to explain that one again?
I'd be happy to. So first of all, I'd like to highlight that there will be some sidewalls, right? There obviously needs to be a railing around this space. It's not a floor to ceiling wall because there is no ceiling, and there's obviously going to be holes in that wall because it is a railing. But that doesn't mean that there isn't additional volume, right? If you want to just picture it as a room that has been cut in half, horizontally, the bottom half could be considered an addition of volume. And at the minimum, what I would argue is, an expansion or an enlargement is what's at issue here. It doesn't necessarily need to be an expansion or enlargement of volume. It could be an expansion or enlargement of space, or as we argue also, an expansion of the use. There's many reasons why this is an expansion. Volume is just one of them.
Would you agree it's flat space though? And there's really, it's not a traditional room enclosed.
Yeah.
Would you agree?
I agree it's not a traditional room, but
So it couldn't count as a bedroom, for example?
it couldn't count as a bedroom because there's a variety of, requirements that you need to, qualify as a bedroom, as I'm sure the code enforcement officer.
So neither one of these decks would qualify as livable rooms.
I disagree. I think they are usable space, right?
No, that's not, they're not usable rooms.
They're not a room, but nonetheless, they are an expansion of the property.
Okay, so let's talk about expansion of the property. As I look back at the history of this property, and this is in the findings of the assessor, okay? The assessor noted that in 1973, a building permit was issued, for the greenhouse as well as for this screened-in porch.
Mhm.
And then there was a prior application to the Board of Appeals to approve the screened-in porch as a non-conforming front setback. It was, in fact, it was a limited reduction in yard size.
Mhm.
Okay, so that was approved.
Mhm.
So that made the non-conformance an approved feature of the property. Now, just to give you a little bit more background on this property, okay? A few months ago, last year, okay? An appeal came before this same board for this property in order to put in a spiral staircase coming off of the deck. And we were looking at that strictly as a limited reduction in yard size, okay? Because it would definitely increase the footprint of the building, and it would encroach upon the setback requirement.
Mhm.
We could not look at anything else, okay? But at that same meeting, we were told that a deck was in the process of being approved.
Mhm.
Okay, and similar deck on the side, which would remove the greenhouse, okay? So Mr. Longstaff pointed that out to us, and, of course, we weren't ruling on that at all. All right, so here we are now, looking at the other side of it. But we turned that one down.
Mhm.
Okay, because we felt that even though there are decks all over this neighborhood,
Yeah.
which the applicant, showed at that time, it just didn't make sense for us to approve that because egress is not a requirement on a rooftop deck.
Mhm.
Okay, that's not a code requirement. So we turned it down for that and other reasons.
Sure.
So here, okay, we're looking at this without that spiral staircase. All right, but it's still a rooftop deck, and then you have a side deck. And these variances were approved in the past on the yard size. And Mr. Longstaff pointed out at the time that his building permit would not increase the nonconformance of this property,
Mhm.
and it does not. So I just wanted to make that point and give you a little bit of background. I don't know if you had a chance to look at this.
I
Any comment?
Yeah, I appreciate that. But I think that our argument still bears weight. And if you wouldn't mind, I would love to explain.
No, go ahead.
So one of the first thing you mentioned was these variances that were previously granted by the Board of Appeals, many years ago. We're not arguing that the, front, fenced in, or sorry, screened in porch is impermissible. I understand that has been allowed. But we're saying is the space above it, that has not been granted a variance. That additional deck has not been allowed to violate the bulk and space requirement. We're not taking an issue with the screened in porch itself, just what is proposed to go above that.
May I interrupt there? Just to confirm, even though the total footprint square footage is not exceeding what's, currently there, on the building permit. All right. There's no expansion whatsoever
Mhm.
in the footprint.
Could you just say that again? I couldn't quite hear you.
All right. There's no expansion in the total footprint of this building.
Yeah.
Okay, so it's not further out of conformance.
I understand what you're
Okay.
saying. Yes.
So you see, the point I'm making here is that even though that's not and that's why it doesn't need to come before the board at all.
Mhm.
Okay, because on here, on the building permit, it was checked off. It does not need to come before the Board of Appeals because there's no new variance.
Mhm.
So I just want to, make these points because you weren't, talking about these things at all in your presentation. And you were saying things that really kind of contradicted the points I'm making.
I appreciate the context.
I
Thank
have no
you.
further comments.
I have just a couple of questions. First off, it's your view that both decks, effectively, or both decks, and I'll call them decks for the time being, were incorrectly approved.
Correct.
Got it. Okay. Would it be appropriate for us to consider each of them separately?
Yes, I believe it would.
Great. The the side deck,
Mhm.
below it will now be a bathroom.
Below it will or will not.
It looks like it will, there's a bathroom in there on the,
So yes, I believe.
maybe
it-
that's a question for custom concepts, but I just, and there's not a bathroom or there's not stuff there today, right? It's just the greenhouse.
I believe so. Yeah.
Okay, got it. Okay, I'm gonna hold the questions then for Mike when he comes up, because he's usually throwing out one on that one. And with that, let me take a pause. Are there any other questions? Richard, do you have any more questions? Oh, he's got his hand up.
Just
Yes.
one. Yeah, thanks. I mean, it seems here that the fundamental issue is with respect to how one defines expanded and enlarged. Right? I mean, you've made this point at the very beginning. Your position seems to be that volume is enlargement. David Burke, when he was just talking a few minutes ago, his position seemed to be square footage defines enlargement or expansion. And I'm wondering if you can talk about any instances in which the courts have weighed in on this question as to what's an expansion or an enlargement. Do you know of any cases where the court has said an enlargement supports your concept of enlargement and not the one that the code enforcement officer has adopted, which is simply the footprint?
So what I'd say is that, court precedent does support our position. With that being said, there aren't specific cases that I can point to, but let me explain that distinction. We're here tonight to talk about a town ordinance, right? And so unless the law court, the Supreme Court in Maine, has determined what constitutes an expansion in Scarborough, there won't be a relevant court case here because each town is different Each town has different ordinances and each town interprets those ordinances differently. So unfortunately, I don't have a court case I can point to that would help us tonight with regard to your specific question. But what I can say is that the law court time and time again has supported those two ways to interpret an ordinance provision or a word in an ordinance when it is not defined, and that is looking to its common usage, as well as looking to other parts of the ordinance to determine what the actual intent in using that word was. And, I don't need to rehash all of my arguments, but I'd argue that, using the smell test, using the common understanding of the term enlargement, this certainly is an enlargement, and looking at the intent of the town, in including that exception for dormers, shows that they intended to have volume constitute an expansion. Whether or not, expansion in volume has occurred is, something for the board to decide. But it doesn't necessarily just need to be volume. It could be usable floor space, et cetera. Mr. Chair, I just want to come back to one thing that you mentioned earlier, that, decks are not included in the definition of floor space. I believe that.
Yeah, that's just from, reading that from our zoning definition.
But notwithstanding, that doesn't mean that they're not part of the structure itself. And this, this ordinance is looking at expansions of structures, not expansions of floor space. And so I'd argue that, definition notwithstanding, this is still an expansion of the usable floor space of a structure, which is an expansion of the structure, even if it doesn't meet the definition of floor space itself.
Richard, you good?
Yes, I am. And I just wanted to just clarify one last thing. In your appeal, you said in maybe the third paragraph, however, the town has made clear that it was concerned about the expansion of previously grandfathered structures and or uses into setbacks through both section 3C and 3D.
Mm-hmm.
And then you quoted a law case. Is the use of the word the town, are you using that to refer to the dormer issue that's there, or is there something in the law case that referenced that, like an amicus brief filed by the town, or some reference to the town in the law case? It wasn't clear to me how the town has made anything clear. So you could explain that a little bit. And then I thought maybe it was a typo when you meant to say the court, but then that didn't make sense either. So.
Yeah, I apologize for any confusion. That case was cited not for any specific connection to Scarborough, but rather because it makes clear that the law court wants non-conforming provisions in ordinances to be interpreted in a way that limits potential modification of those grandfathered in nonconformities to the greatest extent possible, to the amount that was allowed at the time it was the ordinance itself was adopted. And I think this distinction is important. We're looking at what was allowed, and then laws change, and now what can be allowed. And and going back to Mr. Burke's point of the front deck being granted a variance, that deck is allowed, but only that fenced-in deck was allowed. Any expansion of that, this board hasn't had the opportunity to weigh in on it and grant a variance, and that's what we're objecting to, the expansion of what has already been allowed.
So just following up again, the town has made clear. Can you explain how the town made clear this issue? Right. That it's concerned about the expansion of previously grandfathered structures.
So I apologize, Mr. Silkman. I believe you're right. That is a typo. It should read the court. The court has made clear that it's concerned about, folks using non-conforming provisions to expand what is already non-conforming.
Okay. I just wanted to make sure the town hadn't said something about this and that we weren't aware of. That's all.
No, the town
Okay.
certainly has not. That is a typo, and it should read the court.
Thank you. I'm good, Peter.
Okay. Great. We've got our questions. Thank you very much.
Thank you.
Grab a seat. Let me take a break real quick, and I think I would like to have Mike talk now, if that's okay, from Custom Council. Yeah, go ahead. Please, yeah.
You don't need any visual aids. You mind if I move this closer? I'd like you to be able to see these.
Sure.
I'll go back there and speak, or I'll grab
Get
it.
it on camera. that's
If
the
there's a way to get it on camera guy.
thing. Yeah.
Got it? Is that okay?
You're gonna have to
No.
fix this for,
You're gonna have to edit this.
like, as if it was sort of.
Oh, sorry, trying to make it easier. I'll go back.
podium.
Yeah, in front of the podium.
In front of the podium.
All right. Next one. Yep.
Take it around for a while.
That's right.
Mike?
Good evening, Mike Richmond, Custom Concepts Architecture. So I appreciate the opportunity to talk because I think there's some misunderstandings that I want to clarify. And I don't speak the legal terms like all they do. Please understand, both of these areas that we're talking about, the one off the front and the one off the side, are currently space. They're heated space, okay? I keep hearing that the front room is a screen porch. It's a finished space and has been for many, many years. There's no separation, there's no doors between that and the rest of the house. Secondly,
Is the greenhouse
No.
heated?
no,
Okay.
sorry. I'm good. No, sorry, this is the bump off towards the road.
Okay, got it. So the greenhouse is what I think of as a greenhouse. It's not heated, it's,
Greenhouse is actually heated and has power.
okay.
And by what I just learned, the definition with the plants is space. So just want to be clear, both of those are, there's no screen porch off the front of this house.
Mhm.
It's a finished space. Number two, I met with Brian Longstaff 3 times about this project. He was very clear with me, as he always was. Mike, it can't be any taller, any wider, any longer. So I ran back down with my tape measure and I would measure and I would go draw and I'd go back to him. And with the scrutiny on this site, I went back and double checked and then I triple checked. So please understand, when you talk physical expansion, I know there's theoretical expansions being discussed here. Physical expansions, this is no wider than what's there. It's no taller than what's there. And it's no wider than what's there. In fact, the greenhouse off the side, since we're splitting hairs on these discussions, this is the screen port of the greenhouse right here. For some reason, the supports for it are not even on the foundation. I don't know why, who knows why. We are proposing that these actually be pushed back and sit on the foundation. So technically, I know it's little, but we're moving further away from the neighbor by, I don't know, 5 or 6 inches. Thank you. Got it, appreciate that. And a big one I'm very confused about. Both of these, the front bump out and the side bump out, are on are on foundations. We're not removing any foundations. Not removing foundation.
Can we clarify that one? Because on the plans provided, the side bump out has a note saying that you'll excavate down and pour new slab to match existing slab if possible.
No, thank you, appreciate that.
Yeah.
If you see this picture right here,
Mhm.
there's an existing foundation wall. It's kind of odd, but it's been there for a long time, where you can step down into it. It's very stable. I had my structural engineer meet me out there. It's in good shape. The idea is this old rickety structure gets removed. So literally the only demolition is this metal and the wood. Foundation, we clean it off, brush it off, and build on top of it. Down underneath here, for some reason, it's lower than the basement's floor. I don't know, 4 or 5, 6 inches. So it's gonna be an odd step, and we were concerned people would trip on it. So we would pour concrete down in there, just raise it up and seal it up.
Yeah.
But all this foundation, as is, zero foundation work.
So there is already a slab down there. It's not dirt on there.
Correct.
It is a foundation, as I would think of a foundation.
Correct. And in remarkably good shape considering its age.
Peter, can I ask a question?
Sure.
So what percentage, if we're talking about this, just the structure, and we're talking about the side piece with the greenhouse, what percentage would you say that you're demolishing? And then also, what percentage, if we were talking about that plus the whole house, the house as a whole percentage, would you say is because they're gonna be two different things?
Why?
Because they're arguing that, just look at demolition as just those structures, right? And then, well, that's what I gathered at least. And then, Mr. Silkman brought up a really good point that, well, we kind of zoning boards look at the whole property when we're doing percentages. So could you give me, I know you don't probably have the exact, but could
Yeah.
you guess?
If I had to
Both of
guess,
those things, please.
yeah, I would say just in terms of that concrete foundation, maybe a third of it is the greenhouse. And the rest is actually open. You can walk down and you're open. There is another section in the middle that looks like it was put on, probably not permitted. Looks like it's an outdoor shower or something. That would be removed. In terms of the whole house, I could do the math pretty easily. It's a large house, probably less than 5%.
Thank you.
Anything else, Donna?
I guess just, I just want to really point out that we were very careful, Brian and I, to make sure that this proposed deck, we're on the front bump out, we're removing a roof that's tapered. We were very careful to make sure that once we reframed it, we're not taller than what's there. And the same thing with the porch, with the greenhouse on the side. And in fact, the greenhouse is going to be, the new is going to be a little bit smaller than that. Yes, everything else I will leave up to the experts.
Thanks very much. We appreciate it. Sorry.
Yes, Richard, have anything?
I've been looking. Richard's not raised his hand, so he's been good about doing that. So, and he's on mute. So
Okay. Just one.
I trust him. Yeah, he's still on mute. Great. Then what I'd like to do now is give the floor to the town.
All right. Hello, everyone. My name is Grady Burns. I am from Bernstein Shore. I'm one of the town's attorneys, but I'm sitting here tonight with the Code Enforcement Office, representing the Code Enforcement Office. So just to be clear, we are not here in an advisory capacity for the board, but my goal here tonight, given that this is a town permit that was issued, is one, to talk through from the Code Enforcement Office's perspective, what kind of the appropriate kind of scope of the review here is. And then I do have Brian Dobson here, the other Brian, not Brian Longstaff. So Brian, Mr. Dobson was not the CEO who issued the permit, but he is here and available to talk through his understanding of the property and the permit approval process to the extent that the board has any questions. I think here, though, really the factual questions here are not really in dispute. I think the main issue that this board is going to have to grapple with is, and one of you mentioned it, I think, pretty articulately, excuse me, earlier, was really this board's interpretation of what constitutes an expansion of a non-conforming structure. That is really the nub of the issue here. From our perspective, this board is undertaking what we would call a de novo review, right? You're taking testimony, you can take additional evidence, the displays here that the property owner have provided. The code enforcement officer's decision here can help inform your own interpretation of the facts and interpretation of the relevant ordinances. But your job here is to look at this with fresh eyes and determine whether or not this permit should have issued. The appellant, because they're the ones who brought the appeal, they have the burden of proof here, right? Ultimately, for them to be successful, a majority of this board would have to agree with the appellant's interpretation and vote to uphold the appeal. But ultimately here, I think, as Attorney, excuse me, as the appellant's attorney laid out, I think they have presented their interpretation of how this ordinance should be interpreted. It is true. Looking at this, purely from what the courts have said and how to look at nonconformity provisions generally, the first principle here is that the law disfavors nonconforming conditions, right? So generally, language in an ordinance that allows the continuation or expansion of a nonconforming condition should be strictly construed, right? Because the goal here is ultimately to phase out nonconformities over time. That said, your job here is to interpret the ordinance that is in front of you. And I think the fundamental issue here is that your ordinance says some very specific things, right? It says you cannot expand, enlarge, or increase in height a nonconforming structure. It does not say you can't make any alterations whatsoever to that structure. And I think the issue here is that the appellants are trying to read into this language something that isn't there, frankly, which is that any alteration of the structure somehow constitutes a de facto expansion as well. The code enforcement office, when they looked at this, and as the permit findings set out, the CEO at the time found that there would be no increase to the footprint of the property. The proposed construction does not enclose any current open space, and it does not increase the height of the structure. You heard from the property owner's architect that they were pretty fastidious about making sure that that was the case. Ultimately here, I think the board will have to grapple with the question of whether the construction of these open deck spaces constitutes an expansion of the nonconforming structure. The CEO's office took the position that it does not, and for the reasons that are laid out in that decision, namely that it is not expanding the footprint, raising the height, increasing the volume. The appellants use this a term often, usable space. That is not something that's not a defined term in your ordinance. That's something that the appellants have kind of just made up as part of this appeal. Your ordinance does have that language that's already been discussed about living space, and discussion about footprint, what constitutes a room. I think all of those are potentially relevant here, but I don't think the appellants are fundamentally challenging the nature of this construction, although I think they did say that the foundation was being ripped up whole cloth. You've heard from the property owner that that is not in fact the case in the greenhouse. I think that only supports the CEO's interpretation here that there is no expansion of the existing footprint, and therefore no expansion of this non-conforming structure. The secondary point that the appellants raise is related to this question of whether there is a demolition or removal of a building or structure on the property. I think the questions that this board asked of the appellants were getting to the heart of the flaws in that argument. It may be true that 100% of 5% of the space is being removed, but that does not mean that an entire building is being removed, or the entire structure, or 40% of the entire structure. From the code enforcement office's perspective, this is a renovation of a small portion of the existing structure on the property. That does not constitute a removal of an entire structure that would trigger the provisions of section 3C2, which deals with removal and replacement. I think if this board were to adopt such a broad definition of removal, the previous provision that talks about, expansion, enlargement, it would be, I think, any alteration potentially would come under that broad definition of removal or demolition if we're talking about the removal of any portion of an existing structure, right? Which is really what construction does. It removes things and it adds things to a property. So I'm happy to talk through, the legal interpretation here. Ultimately, your job is to apply your understanding of the facts to your own interpretation of the ordinance. You do not have to agree with the code enforcement office's interpretation, to be clear. But the town historically has dealt with these types of applications in this way, have looked at these factors to determine whether or not an expansion of a non-conforming structure is occurring. And we believe that analysis that the CEO's office does is eminently reasonable. Again, these are not defined terms in your ordinance. So adopting a reasonable construction of what these terms mean is part of the everyday work that the code enforcement office has to do. Likewise, here, you have to make that interpretation for yourselves. But we would encourage you, as you review, to ultimately, if you agree that the code enforcement office's interpretation is reasonable here, we would encourage you to use that interpretation as well. But happy to answer any questions on the legal side. Brian's here to talk about anything on the ground on the property as well.
We'll do this the same way. We'll give Richard the first chance to ask me questions for these. Richard, anything from you?
Yes, I do have one, Peter. Did you have a chance to review, or you must have seen the appeal that the appellant provided?
Yes.
There's one case that they reference in that it's Kennebunk, Shackford and Gooch.
Yeah,
case.
Shackford v. Gooch. Yep.
And I took a look at that as far as I could get with before I hit a paywall. So I didn't get all the way through the case because I didn't want to subscribe to Lexus or any of these other things that you guys pay a fortune to subscribe to.
Yeah.
But it struck me that the deck issue was very similar. And this case is very similar to that. That
Yeah,
could you comment on the quote there where they say when an ordinance prohibits the enlargement, and landowner cannot, as a matter of right, alter the structure. And it seems like by leaving this with a code enforcement officer, we're giving them the right. If they have to come before us and get a variance, then we're giving them permission. And I'm wondering if you could sort of talk about this case in relation to that and whether it even matters.
Yeah, absolutely. No, you raise a very good question, right? And I apologize for the paywall on behalf of all non-attorneys who try to read cases. It is very frustrating. So the case that you referenced, Shackford v. Gooch, it's a 1984 case, so it's getting up there, but it's still widely referenced in the municipal bar. Actually, the other half of that case is talked about more often, which so in that case, there's a code enforcement officer that basically told a restaurant owner, without issuing a written permit, yeah, go ahead, build this exterior deck, totally fine. You don't need a permit. You're all set. They built it, and then another code enforcement officer came in, a little while later and said, hold on a second, you can't do that. And the property owner was like, well, you told me I could. And that case stands for basically the proposition that if a code enforcement officer doesn't issue a written permit when one is required, it's not reasonable to rely on what a CEO says. Sometimes, you have to get a written permit. So that's usually what Shackford's quoted for. But here, the other half of that case deals exactly with what you're asking, which is the court dealt with this question of when does an expansion of a non-conforming use occur? Now, the appellant's attorney is absolutely correct that different towns have different language in their ordinances. So ultimately, you have to interpret the language that you have. It's not going to be identical to Kennebunk's, but there is case law. And Shackford kind of started it. I think there was a later case back in 2001 Lewis versus Maine Coast Artists, which kind of expanded on Shackford's arguments in that case. The upshot is that the courts have said in a few instances a significant alteration of an existing property that doesn't that may not on its face result in an expansion of the the footprint, the dimensions. A significant alteration can sometimes be considered significant enough to constitute an expansion, right? So in the case of Shackford, it was a situation where facially the facts seem similar, but we're talking in that case about a restaurant use that was essentially creating a large and substantial outdoor eating space, an outdoor patio eating space, that the court in that case said, that alteration was substantial enough that even though they were staying on the same footprint, they were staying on the existing roof, it was significant enough to constitute an expansion when you construe the ordinances strictly, which you have to do here for nonconformities. The Lewis case that came later was a little bit different, but they said in that case, they emphasized that the alteration has to be substantial. So I think here, you could look at those cases and say, well, even if you aren't expanding the footprint necessarily, you could find that there is such a substantial alteration of the property that results kind of in de facto as an expansion of the nonconforming structure. I think the CEO's office's view in that would be that threshold has not been reached in this case. We're talking about areas, the entire structure is currently dedicated to a residential use. The proposed deck areas are not of a scope and scale that would fall within that substantial alteration. You're talking about an enclosed, and then the enclosing of the greenhouse space, in fact, is arguably reducing the visual imprint of that portion of the property on the abutters as well. So you're having the inhabitants of the property are still inhabiting the same locations on that property, but you're adding deck space. So I think the decision, Mr. Longstaff's decision, I think speaks for itself in terms of the factors that that he reviewed when he issued this permit. But certainly as part of your analysis, you could look at the intensity of the alteration as well. But our position would be that threshold hasn't been met here, and the appellants certainly have not presented enough to disturb the underlying permit.
To follow up, you referenced in those cases a substantial alteration. Do you know when they were looking at that in those two cases, did the notion of substantial, was it restricted to just the physical construction of the deck, or did it take into consideration the impact that it might have on surrounding properties? That is, you could have a substantial alteration that changes a use that has an impact, even though the actual construction was quite simple. I mean, a 10-year-old could do it.
Yeah. I think the distinction here. Sorry, I didn't mean to cut you off.
No, I said, do you recall whether or not that substantial was related solely to the construction, or did it spill over into the subsequent use of the space?
So my recollection of those cases is that they were looking at the substantial impact of the construction itself. And I think the distinction here is the difference between a non-conforming use and a non-conforming structure. I think if you have a non-conforming use, it would be entirely appropriate to look at an intensification of that non-conforming use on a property, and whether that constitutes an expansion of a non-conforming use. I think when we're talking about allowed uses on otherwise non-conforming structures, to my mind, the relevant inquiry there would be the scope of the actual structural change.
Assuming for a moment that we were to uphold, to deny let me back up. If we were to uphold the appeal, then that would mean that they would have to then, the owners of the property would have to then come for a variance.
They may.
Assuming they wanted
So
to pursue it, assuming they
uh,
wanted to pursue construction.
That's
And
that's
so-
a potential outcome if you grant the appeal, certainly.
Yes, that is. And so when they come for a variance, wouldn't one of the criteria that we would look at be the impact that that construction has on the character of the neighborhood and on the budding properties in considering the appeal? And I'm wondering, what you just described to me is the use, and I understand non-conforming uses, but in the appeal process, we often look at the use of the property to determine whether or not it would have a change, it would physically or affect the neighborhood in question. So aren't we going to get there eventually if we were to uphold the appeal?
So I would respectfully say, first, I think that this board should focus on the appeal that is in front of you. If there is, as a result of that, a subsequent variance application, then certainly you'd be absolutely entitled to ask those questions. But I don't want to go too far afield down the hypothetical because we just aren't there. I think the task before this board today is to look closely at the language of section 3C and determine whether or not, under your understanding of what expansion means, whether this proposed construction constitutes an expansion of that non-conforming structure.
Our attorney, I apologize. I was asking you for some advice to the board, but I shouldn't have.
Real quick, do you want to grab your poster? Sorry about that. Shelley, yourself?
No.
No comments.
I guess I have a question. Does the town or does the town or ordinance incorporate railings in height? In determining height?
Mr. Dobson might be able to comment on historic practice. I think if a railing otherwise exceeded the height of the structure, I would say potentially you would include that in the height calculation. My understanding here is that the proposed railings are all below the roof line or the highest roof line, although I could be wrong. I believe that is the case. I think there are instances where it could be part of that height calculation. Here, certainly the maximum height of the structure is not being exceeded.
Got it. And that one, might go up. I do have a question for that.
To clarify, the railing system required by code, of course, does stick up higher than what is there now. But from my understanding, Brian, please tell me if you believe differently, railings are exempt from height determinations.
Why is that as a safety? Because
It's considered, I think they use the word appenditure. It's similar to cupolas, weather vanes, things like that don't have floor area. But we've done many projects in Scarborough where the railings itself exceeded height limits because they're exempt.
Actually, I have the definition. So
Yeah.
I was making an educated guess, but you have a specific definition in the ordinance.
It's just before I go, I don't want to forget the owner of the property is online and would like to speak before we're done, before it goes to vote. Thank you.
So, sorry, Mr. Chair. I should have looked in the ordinance first before I spoke out of school. So building height is defined in your ordinance as the vertical distance measured from the average elevation of the finished grade at the front of the building to the highest point of the roof on a flat or mansard roof, and the average height between the eaves and the ridge for all other types of roofs. So I think based on that definition, in looking at the height of a structure, you'd be looking at the roof height and not the associated railing.
And that's for the building as a whole. We've got multiple roof lines, quote unquote, on this property. So do we interpret it as just being the top roof line? Or how does that work? And I bring this up, you've got the porch in front. that's got its own roof line, right now. Um, when we calculate the height of that, does that include the railings now that go around? So, yeah, exactly, yeah. And for those of you following at home, I'm looking at, I think the same section, it's on page 4 of 26, in the definition section of our code.
Yeah, so I know that when CEO Longstaff looked at the application, he determined as a matter of fact that the height of the structure would not be increased as a result of the application. But again, you know, as part of this board's own review, I think you would have to look at the ordinance definition and apply that to the facts here.
Yeah, and to be clear on that one, it's clear that if you just took the floor of that deck or the deck on the side porch as well, you're within the current height. But if you added in the railings, now you've got the railings go above that. Yeah. So that's, and okay, and I appreciate that. Is there anything else that you'd like to add?
Brian, is there anything else?
Brian? Okay.
The board has no questions.
I'll close the town's comments then. The owner of the property is asked to, but where are they? Are they?
So if you're ready, I can allow. them
Yep,
to
yep.
speak. Mike Schott, you should now be able to unmute.
Ready. Good evening, everybody. How are you doing?
Good.
Good. Just make is my not a huge deal, but just curious. It looks like it's just sound, no video, correct?
What?
Yes, just audio.
Could you say that again? Sorry.
Sorry, you guys can hear me, but can you see me? Is there no video?
No video.
No video.
Okay, that's totally fine. My wife just told me to dress up for this, so if she asks you, I'm wearing a really nice shirt. So yeah, we're here today, and as you know, and you know, the town previously reviewed and approved from zoning board CEO, Mr. Longstaff, this permit back in October. These delays have been very costly and they've been very frustrating for me and my wife. FYI, Michael Schott, 5 Bliss Street, Scarborough, Maine. You know, I'm going to try not to overly, you know, repeat a lot of the stuff that was happened today. But I think it's important coming from me, the homeowner, that you hear it directly from me. So I will be repeating some stuff that was talked about today, but I promise not to talk about dormers. The appealing party has falsely presented the facts and a couple of things today. And even though we already, I believe, came to the conclusion, I think it's important to hear it from me. They mentioned 3 times today, and also in writing, that on the side of the house, the existing greenhouse portion, that there's going to be demolition of the excavation all the way down, repouring the concrete and the foundation, and that is not the case, which I think we all understand that. They also put that in writing. Also on that side, and there's already there's a heat, and there's heat and bear with me, electricity already ran to that. And actually from the inside of the house, when you're in the basement, this greenhouse, it's part of the house. It was part of the house. It's been part of the house for 55 years. When you're in the basement, you can actually walk directly through the basement into the greenhouse. So it's not like a separate attached thing. You can actually walk right into it. Also, they mentioned about 3 times today, that or a couple times today, and also in writing, which I believe is not a fact. They're calling, now we're going up to the first floor. We see that Mr. Richmond showed you the pictures. They kept on calling it a screened-in porch. This is not a screened-in porch. This is original construction. It's been there for 55 years. It is the exact same windows that are through the rest of the house. It's open. It has heat. It's conditioned, etc. So the fact that they called it a 3-season porch again today, that's not the case. It's obviously just like the rest of the house. It's a 4-season insulated window. And you can see that by the pictures. It was very discomforting to hear some of this stuff because the opposing party has lived, you know, some of their members next door for 55 years since 1971 when this was built. And a lot of them, it's my understanding, and factually, have actually been in the house on more than one occasions, even since my wife and I took ownership of this house over 10 years ago. So they've been inside, they see how it is. So to see in writing and also verbalizing multiple times that it's a 3-season screened-in porch. You know, it was just very discomforting to hear. Again, this whole process and delay has been very, I know I'm repeat myself, I apologize, very frustrating. We got the permits back in October. We were ready to go. We're fighting winter, as we all know, as Mainers. Then there was a Board of Appeal. I guess there was supposed to be a meeting that's next scheduled on I think it was December the 10th, which I apologize that I couldn't be there today. But on December the 10th, I was planning to fly out to actually be towards it. But it's my understanding that the appealing party requested to be moved over to January. So again, that pushes out a project even more, which has been more costly and frustrating. Another thing that the appealing party mentioned at least 3 times in this thing today, and also in writing, is it's a rental. It has, multiple people can be there. Again, when we're talking about a zoning board issue, that should have nothing to do with the fact that my wife and I decide to rent out our house or not. It should have absolutely nothing. The fact that they keep on bringing that up multiple times, it should have nothing to do with it. And the fact of the matter is that this house in 2025, we only rented it out 3 weeks. In 2025, only 3 weeks. In 2026, this year, we only have it scheduled right now to rent it out 1 week. And I honestly don't believe it's going to be rented out more than that. It may, but as of right now, we only have 1 week booked. Again, additional falsely presented facts is they're saying, oh, the intensity of this house is going to increase. This is just the falsely accusing the purpose of the house and even the unknown purpose. We've never had any complaints. Again, the fact that it can sleep more people, it's a nice house, should have nothing to do with the zoning board's swaying their decision in this. So again, a lot of the stuff that I'm saying, I apologize. I think it's important for the board to hear it from me personally. Again, I apologize I couldn't be there today. But this is just, it's costing us a lot of time, a lot of money, and a lot of heartache. So, but I appreciate all of you and the opportunity for everybody to speak today and to go through this process. So thank you for that.
Thank you, Mr. Schott. Are there any other public comments? No? Okay. Oh, and Mr. Flaherty, you're not Mr. Flaherty, but yes, you may.
We might just have an opportunity to quickly respond to what's been said.
I'd rather not. That kind of gets into a ping pong match, unfortunately. So, but thank you. I appreciate where you're coming from.
Just, and again, it is your decision. Obviously, the town has had an opportunity here, and the homeowners have had an opportunity here. Our argument to respond, we were unaware of what they were going to say tonight and would like to contest some issues ever so briefly.
I will give you 2 minutes.
It's 2 minutes, thank you. And I will keep it brief.
2 minutes.
Mr. Chair,
Yes.
are we closing public comment?
Yeah, we are.
Or-
No one actually responded. No, I didn't see it, and I had specifically looked to the crowd. So no, we are closing that. This will be a final
I
response
just wanted to clarify.
from the appellant. Thank you very much. I appreciate that. And I'd like to remind everyone in the room that we are a volunteer board that uses our time, that is offering our time for free to help deal with the issues that this town has. Please respect us and use our time carefully as well. Mr.
Thank you. I will keep it brief. First, let me say, as a member of the Board of Appeals in Portland, I appreciate your time and what you're doing for your hometown. With regard to what Mr. Burns said about the town's standard practice of reviewing these types of requests and limiting what could constitute an expansion to those 3 previously discussed criteria, I would just like to note that when originally reviewing this application, the permitting office, or potentially the code office of the town, noted that removal and reconstruction in this location will require full compliance with the current setback requirements, or the applicant must obtain relief, in parentheses, variance, from the Zoning Board of Appeals. Obviously, that decision was later walked back, but I would just like to highlight that the town might not be as consistent in using those 3 criteria as suggested. Last, I just want to speak to that front room. Obviously, the homeowner has made clear that it is not a screened-in porch. It is a fully functioning part of the house. I don't think that really bears on the arguments here. We're not concerned with that specific room. We're concerned with what's going on top of that room. That room has been granted a variance. We just don't believe that that variance should be extended to other appurtenances to what has already been granted. It's a slippery slope. Once a roof deck is granted, would a staircase be granted, et cetera. I hope I stayed under my 2 minutes. Thank you.
Yes, you did. Thank you. I appreciate that. Are there any other questions from the board for the appellant or for the town or for anything like that? I have one final question. The tax assessment document lists 3 bathrooms in the house. Would this new bathroom downstairs give it a 4th? Okay, got it. Thanks.
Mr. Chair, as I pointed out earlier, the building permit does not call for an additional bathroom, and that has not been permitted.
Yep.
There's 3.5 bathrooms before, 3.5 bathrooms after.
I agree.
So that's not permitted.
But let's talk about that in a moment.
Okay.
So with that, I'm going to close the presentation from both the appellant and the town and enter into our session. First off, in terms of what we will find, or we obviously we're going to rule on the appeal tonight. In terms of the findings of fact we have for that, though, we'll need a motion. So I want people to think about what we should be outlining for findings of fact as part of that final vote. And just, I'll leave it at that because we're not ready for a motion yet, but when we get to that point, let's get there. So, with that, let me start with Richard. Richard, if you could kind of initiate the discussion for us as a board, and we'll go from there.
Sure. The appellant has made 2 arguments. The first with respect to enlargement, the second with respect to demolition, and the unsanctioned or impermissible reconstruction. I think the second argument has been pretty much debated to the point where it's not going to fly. I don't think that what they're doing with the side greenhouse qualifies as demolition, and therefore I don't think that their second argument holds water. The first argument is a little trickier. The terms enlargement, expansion really aren't defined. There's a good argument to be made that square footage has been the historic standard and the standard that ought to be used consistently going forward. I think there's a good argument that varying from that to begin to consider other criteria could create an awful lot of work for the zoning board going forward, because there may be a lot of instances in which building permits are allowed for what we have never considered to be expansion historically. On the other hand, there is this notion in the background that says, the purpose of nonconformance is to eliminate it over time and not to expand upon its use or expand upon getting more non-conforming activity at the same location. So I'm still a little torn on the first argument. It's it's 30-70 right now against, but I see a little bit of a wedge there, and I'd be willing to consider if other people feel like the first argument is a little stronger.
Okay. Kelly?
I agree with everything that Mr. Silkman said. I think that the second, I also agree there's 2 arguments here. The part about the demolition, we really do work as this house as a structure as a whole, and that I just is not convinced that this is being demolished in the sense of the descriptions that we have been given and kind of came up with and are using tonight. I can't get on board with that one. Expansion, I also am having a difficult time. If this deck was enclosed and had a roof, we would be talking about, it would be a different thing, but this is going to be a flat surface. And arguably they're, getting rid of square footage underneath. So if we wanted to talk about like volume, they're decreasing the volume of this house. So I have a hard time, you know, reversing what Mr. Longstaff came up with. I'm not convinced. I would love to hear other thoughts. And I might have more to expand on as you guys
Sure.
talk. So it's hard not to interrupt people. I'm sorry.
Okay. David?
Okay. Just looking at the findings and facts that Mr. Longstaff produced prior to issuing the building permit, he did a very thorough job. And as Mr. Burns correctly pointed out, he is meticulous, and I've observed that over years, about making sure that everything is done exactly right. That's, I mean, we're going to miss him, but he's one of the best I've ever worked with. So, you know, I know for a fact that he was very careful in making sure that we were not exceeding the nonconformance of this property. And in fact, it's, it's actually, we're making a little bit slightly, maybe 4 inches or something like that, more in conformance. So I think that's to be commended. And there's documentation of the, permits that were issued in 1973, and then the subsequent approval by a former zoning board of appeals for the so-called enclosed porch, which, as we can see, wasn't really an enclosed porch, but that's not uncommon. I mean, this happens. And it's really all the information we need right there to show that this is all done in conformance with our ordinance, is following the process properly. I think it's very clear to me that this does not establish any kind of increase in volume. That I look at things strictly in terms of square footage. And if you look at decks in particular, okay, these are not living spaces. A deck is a deck, okay? It doesn't count as living space. This has 2 decks on it, okay? And I don't know about this issue about the bathroom, but that's not on the approval. So as far as I'm concerned, that's not part of any kind of an issue, unless that can be resolved somehow. Perhaps that was a mistake that was made. Perhaps Mr. Longstaff checked the wrong box. I don't know. Okay, but that's something that later on it needs to be resolved, and it's not our job to do that. So I think Mr. Longstaff did a stellar job following the process, following our ordinance, following the zoning regulations, and really deeply understood what they are in Scarborough. And as was correctly pointed out by both attorneys, okay, every municipality has their own ordinance. They're all different, okay? But he knew what our ordinance is, and I think he applied it properly.
Well said, David.
Pardon?
I just said, well said.
I've got, first off, I think we all are in agreement. The idea that there's a destruction taking place here just doesn't jibe, both in terms of magnitude, and also now that it was clarified that the foundation really is not being touched. If anything, it's being, filling in to get it leveled is very different from ripping it up or blowing out a wall or anything like that. So having that clarified to me puts the demolition argument off to the side. I do think we have an ongoing open issue, and I somewhat agree with Richard on this one, is the use of the building, the porches. We've had a lot of porch discussions, actually, as a zoning board of appeals in the Higgins Beach and the Pine Point area. And I don't think we've ever really settled on, does the railing include the height or not? We typically have other issues that kind of come into the discussion of porches. So we have typically approved the porches and things like that. But this will increase the height line on that one, and I'm concerned about that one, because that is that's doing what Brian effectively was trying to work on and not affecting the dimensions of the house. I know there's a view that dimensions may not include things like porches, but I think, again, it's a built structure that's, I can't see through it as well as I used to be able to. So I'm worried about that one. I'm worried about that one.
May I comment on that before we move on to your next?
No, let me finish, because I let you guys finish.
Okay.
Come on, Brett, come on, Dan. So I'm wobbly on that one. The last one though, and Brian, I have a deepest respect for Brian. Brian was a wonderful CEO to work with, especially in this context. But I'll be honest, the permit's odd. The permit doesn't show evidence of bathroom being built. If Brian knew that, he wouldn't have let this go through without indicating that the new proposed bathrooms is 3.5. By the way, that would require the water sheet to be refilled out because you're now adjusting the amount of water use usage. So that's odd. There's no, and to me, that actually starts to intersect with the question of the intensity of use. You have this admittedly heated, enclosed greenhouse. But now you're going to put a bathroom in there. That's a markedly different use of that little punch out of the building. Now it's still within the footprint, but I got to be honest, it's a different use, and there's something odd that this didn't make it into the permit. There's something that's weighing on me about this not being included in the permit. So I'd like to hear from Richard, but before I do that, I'll let David now interrupt.
Oh, thank you, sir. Regarding the rail issue, I would like to just point out that Mr. Burns explained what the current language is regarding rails.
Mhm.
And if you look at the photographs of this building, those guardrails around the decks, not porches, okay?
Yeah, but-
These are decks, okay?
Yeah.
These guardrails, the porches have walls and such,
Mhm.
these don't, okay? But these guardrails don't come close to the total height of that building.
No, not the total height at
That's the
all.
way
It's
measured.
it's the existing, and this is only for the one above the not the greenhouse. The greenhouse is actually, I think, can be designed or is okay. The roof line currently on the front of the house, if you look at the pictures, it slopes up a little bit, but the height of the railing would be above the point at which the roof currently slopes.
Well, perhaps I misunderstood Mr. Burns, but I thought Mr. Burns was pointing out that it's not that line, it is the total height of the house.
I didn't feel clarity on that one. So
Okay, I
yeah,
did.
okay.
All right, well.
So okay. So those are my comments. With that, first off, Richard, anything else from you? I'm always interested in hearing your thoughts.
Sure, no, just, I'm a little troubled, Peter, by the concept of intensity of use. I mean, it's not in the zoning code at all. I mean, clearly, a husband and wife use a home much less intensively than do, a husband and wife with, with 10 kids. And I don't think that there's anything in the ordinance that allows us to go to intensity of use as a criteria. And I think the notion of expanded and enlarged and increased in height all relates to physical structures, not intensity. I know the appellant wanted us to go there, but I don't think that we can. And not only that, but I think it'd be very dangerous to, for lots of reasons. And we have other means of controlling intensity of use. The number of bathrooms and sewer systems and so on, and noise ordinances and setback requirements and all of those things that deal with that. So I think we need to stay away from intensity.
I agree.
So
I
I-
think we should just assume that this is gonna be used as a deck and like any other person would use a deck. I mean, and it could be just holding plants in the end, and that's not very intense.
No, it's just again, I think about all
And there are ordinances for the town in place, should it end up being this raging party house, and that's not for us to say, and they can take care of that.
No, you're right. That's not that is not within the purview of this.
I
body.
did have a question about this bathroom. Should we even be concerning ourselves with this?
Well, I don't know. I'm glad we have at least discussed it on the record.
And then you
I'm not
said
sure what
that-
else we could do.
You said that the tax assessor said it's 3 bathrooms, but the permit says 3.5, so they could put in a half bath, then
Well-
it sounds like,
But
right? Is that what?
well, my point is that, my point more than anything is there's a weird disconnect between the assessor's document, the permit, and,
The plans?
yeah, and the plan. So it's,
Yeah, 3.5, but you said it was, oh, so no change, okay.
yeah, so
Yeah,
something.
I didn't
It's
catch
more of a
that
statement
when I
that
was looking.
I wanted to highlight it. We've highlighted it in the presence of planning staff and, the code
Can we
enforcement officer.
have Mr. Richmond come up and talk to that, or are we not? Oh, no, she's saying.
Well, it's not-
Doesn't really matter what's,
yeah, it doesn't matter. It's just, again, I raise it as something.
Well, I mean, doesn't it potentially matter because I guess we're
It's
really,
for us to do.
it's because conformity and,
We're really answering a court question of conformity. on
Okay.
this one, so,
yeah.
But again, and part of it, I don't wish to cast aspersions on anyone. It's just, we're used to a very, very precise standard of work from Ryan. It just didn't come through on this permit. So that's all I'm saying.
I don't know. I mean, I think it was I think it was pretty thorough. I think there's probably, that was my guess. I don't want to guess, but
Yeah, let's not speculate.
I think if he had known about it, he would have had added it in there, but I guess that's still conjecture. Sorry.
Right,
You
yeah.
can strike that, I guess.
Okay, so I think we're ready to discuss a motion for the appeal.
Mr. Chair, can I just raise one other issue?
Sure.
The appellant made an effort to link the expansion and enlargement with the notion that an exception was made because, to allow for dormers to exist. And that exception was very detailed in terms of how it was structured. But what's interesting about that exception is it only relates to height. It does not relate to enlargement and expansions generally. It more is it's a height issue. I'm not sure that there's much there that we can go on with this exception. So I'm not convinced by that argument.
Okay. So work with me on this one, and Richard, Shelley, David, you can feel free to correct my language if you need to, or propose something different. What I propose is that we find on the 2 arguments made by the appellant. The first being that the construction violates setback requirements by impermissibly expanding a non-conforming structure through expansion of floor and living area and intensity of use. We make a set of findings on that. And then we have a set of findings that this was allowing a prohibited reconstruction, which would have been effectively preceded by an illegal teardown. So on the first issue, would someone like to propose some findings of fact? Richard, any help on this?
Yeah, I think that we can find that the code enforcement officer's findings of fact in the issuance of the permit are correct. And that relying upon those findings of fact in terms of the dimensions, the construction that is being proposed, we can find that this is not an enlargement or an expansion or an increase in the height of the current building. And therefore, the issuance of the permit with respect to this criteria is valid. And accordingly, on this criteria, we would deny the appeal.
My one proposed correction is rather than saying correct, I would say is a abundantly reasonable interpretation of the town's ordinances. Because
think that's a
correct,
good
I'm a little
correction.
worried about, and it gets this whole issue of what the hell's a railing? And is a railing part of the height of the building or not? There should be, that requires an interpretation. Brian interpreted it to not be part of the height of the building, and I think that's an entirely reasonable thing to do. But I worry about the use of the word correct. So otherwise, though, I thought that was really eloquent on the spot. So, okay, could I have, we'll vote on that then. Richard, how do you vote on that finding?
Yes,
Shelley,
So we're voting.
voting on the finding of
accepting
fact, this finding.
that what Mr. Longstaff issued is abundantly reasonable.
Yes,
Yes.
Yes, also here.
I will vote yes. Then the second issue will be, did Mr. Longstaff correctly not view this as a prohibited reconstruction? And what I'd say is that's a little easier and I can actually propose it because I'm glad Richard was here for the first one.
Can I add something from staff?
Sure.
I just want to flag that with the de novo proceeding, it's more focused on the findings established within the context of this meeting as the evidence has been collected, not procedural errors and in the past. And I know that might not be, I just want to.
it's a de novo proceeding, but can't we rely upon the record and bring it
Yes.
into this proceeding?
Yes, just being cautious. Thank you.
Okay. So for the second issue, we find that this was not a prohibited, the proposed permit does not cover a prohibited reconstruction, but in fact, it does not meet the terms of a prohibited reconstruction. Full stop. Richard, are you comfortable with that?
Yes. In fact, if we're voting, I'll vote yes.
We are voting yes. Shelley?
Yes.
David? I vote yes as well. On that basis, do I have a motion to approve the appeal?
We wanted to,
No, we did this last time. We have a motion to approve, and then we vote no if you don't want to
Yeah.
approve it.
Exactly.
okay.
It always has to be affirmative.
Yep, exactly.
Here's
This
the-
happened last month too, so.
Okay.
So can I have a motion, please?
So moved.
Thank you.
I will second that.
Shelley seconded. Doreen, if you'd call the roll.
Peter Freilinger,
No.
David Bork,
No.
Michelle Stevenson.
No.
Richard Silkman.
No.
The appeal is denied. Thank you very much. Okay. Next on the agenda. Is election, we already covered that one. We're gonna move that to next one. Zoning board comment, any comments?
Peter, just one
None.
quick question.
That's
on the
fine.
Just-
Richard, do you have
on the-
anything?
on
Oh,
the-
Richard's got a comment. Yes, Richard.
Yeah, just none. It's very simple. On the timing of these new members and because my term expired also, I told them I'd like to continue to sit, but I haven't heard anything. Do we know when the council will actually make a decision as to who's going to be on the board?
I think Autumn can speak to that.
Yes, that decision will be finalized at the council's February 4th meeting.
February 4th meeting. So has the appointments committee already met?
They met today, yes,
Oh.
at 4 o'clock.
Great, okay. So that's the answer, Richard. And remember, you serve until you're allowed to leave. Richard, you're staying with us. Then and that was really my comment, just to see what the progress was on that. Thanks to everyone who deals with these issues, and we appreciate your volunteer time. Motion to adjourn?
So moved.
Second.
Sally second, all in favor? Aye.
Aye.
There we go. Take care, Richard. Meeting's
Take
adjourned.
care, guys. Enjoy the weather. Bye-bye now.